views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
All right, coming up on this edition of Today's Verdict, a creditor is someone who has the right to a debt. But what happens when your debt is sold to other creditors? How do you clear your name? Who has priority over the monies you owe? Our expert on set will help clear the air. Next up, when you show up to work, neither your skin color nor gender are relevant. But sadly, this is not always the case. This type of discrimination is alive and well in the workplace. Tonight, we'll let you know how to protect yourself. As you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. All right, hello, welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesch. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us on Facebook at Today's Verdict and check us out at bronxnet.tv. A creditor's right includes the right to collect a debt. But what if your debt is transferred to another creditor? How often does this happen, and how can you protect yourself? Finally, are there ways that you can avoid bankruptcy? Well, here to tell us more is attorney Robert Michelson. Robert, you're returning to the show, and we love it when people come back.
I'm glad to be here.
All right, let's take a step backwards. You have somebody in the Bronx. Right? They're looking to run a bodega, to buy a bodega, and start a business. How do they generally go about that just to secure credit so they can open up their own shop?
Well, there's a couple of ways. One, they may have been planning for this for a long time and they've been saving money for that purpose. Or they may go to a family member and say they want to borrow some money. The more common way is to take out a loan. And if you're a small business owner or aspire to be a small business owner, there are a number of programs available through the Small Business Administration. Especially if you belong to a minority group where there is a desire to encourage ownership of businesses, you can get a loan on very favorable terms. And you can use that to purchase a business that somebody else owns, or perhaps just start from the ground up with your own business that nobody's owned before.
All right, well, there's a difference between what's known as secured debt and unsecured debt. What do we mean by that?
Well, a secured debt is one where you have said, if I don't pay this debt, here is something of value that can be used to satisfy it. So perhaps if you own a bodega and you have some equipment there, that you can say, if I don't pay this debt, this equipment is available to you. You can take it, sell it, and collect your debt. An unsecured debt doesn't have that benefit. There's nothing backing it up except for your capacity to pay. So obviously, a secured creditor has a real advantage over the unsecured creditor.
Right, because when I think of secured debt, I think of a car lease where the debt is secured by the actual car, or a mortgage. The debt is secured by the actual home, so you really tangibly know what that particular what it's secured by. Sometimes it can get a little vague when we're talking about let's say a shop where you're selling things to the public, but there are still ways to secure a debt. Am I correct?
That's correct. For example, somebody loaning money to the business can say, I want a lien or secured claim on your inventory so that if you default, I can then take the inventory and sell it. Or you can even have a lien on the lease. So you own a bodega, you have a lease. That lease has value. That can also be secured.
Or maybe the good name of the business. Let's say you've had other stores someplace else, and it's well known throughout the borough that, well, I'm securing that name. I want to use that name in the future for myself. Could you do that?
Absolutely. So if you have a name, a trademark, you're Joe's Bodega, and you happen to have 4 or 5 Joe's Bodegas.
You think of Ray's Pizza. right? How famous Ray's Pizza is throughout in New York. I'm sure that was secured debt in some way, that if you don't pay, I'm using Ray's Pizza in the future. That because everybody knows Ray's Pizza. But you're right, I guess you could do that with a bodega as well, Joe's Bodega or something like that.
That's correct. Now, the name or whatever it is that you are using as collateral to secure has to be protected. That's a whole nother topic, how you go about registering the trademark so it's valuable to somebody else.
What about your own personal assets? Let's say, sure, you want to open up the bodega and you want to start selling to the public, but you also have a home in Jersey, or you have a yacht or something else that you want to make sure that nobody can grab. How does that work?
Well, it's frequently the case that the lender, the bank that would give you money, would say, in addition to whatever assets the business may have, I want you to personally guarantee the debt. And in fact, I would like you to give me a lien on your home. Now, if you already have a mortgage on the home, that mortgage comes first. So maybe this would be what we call a second mortgage. And if there's enough value in the home after the first mortgage is paid, then the lender who is owed money by the business can look to that as well.
All right, Robert, let's talk about the real reason we have you here. Things are starting to go wrong at the bodega. And now debt is piling up. Things are going poorly. What happens next when you can't pay the loan back, you can't give your creditors what they want? Do they come in, they take your bananas? I mean, tell me what exactly happens at this point.
Well, the first thing I always tell anybody who comes in who's having a debt problem is, let's see what we can do about trying to negotiate with the creditor. Often it's the bank, and see if we can work out something, because a negotiated resolution is always the best route. But sometimes you can't do that. So the alternative, or one of the alternatives, is to file a bankruptcy petition. Now, there are different types of bankruptcy. One type of bankruptcy, which we call Chapter 7, is a complete liquidation of the business. You basically give up, and a trustee comes in, and that's the end of it. The other option, which is called Chapter 11, gives you an opportunity to pay your creditors off over time, keep the business, and work out your problems that way. Now, recently the law has changed to make it easier for small businesses to go through Chapter 11. It's been streamlined in a way that expedites the process, that makes the requirements less stringent, and consequently, if the law works the way it's intended to work, there'll be a higher success rate and more businesses will be able to survive.
So let's walk us through. You realize at this point that you're not able to pay your debts, and you've also tried to negotiate with the bank and the debtors, and that's not working out either. Do they file the petition in bankruptcy court? Do you get ahead of it? Walk us through the very beginning stages, and where does this happen? State court, federal court, something else?
Well, it's only in federal court because the bankruptcy laws are federal laws. And there are two ways to find yourself in bankruptcy. One's called a voluntary bankruptcy, where you decide that you're going to file a bankruptcy petition. The other one is when creditors, and you have to have at least 3 creditors who join together, file a bankruptcy petition, and you then have to either agree to it or you can fight it. That's not an ideal situation. You always want to be ahead of it. You want to be the one who's control of the process. So if you can, be proactive. If negotiations fail, you can't work something out, consult with a bankruptcy attorney, particularly one who deals with commercial bankruptcies, because there are personal and commercial bankruptcies, and they're not exactly the same. And get ahead of the game that way and work out something and present a plan to your creditors.
What always confuses me, Robert, is the priority of liens. I never know who goes first. You would always think it would be the bank, but then again, maybe it's the person who sold you the equipment for the business. Or then again, it may be a family member who loaned you money for the business. Who gets to walk in front of you or walk in front of the bankruptcy and judge and say, I get paid first?
Well, it varies according to what specific collateral has been offered to secure the loan. So the bank may say, we're taking a lien on everything you own. That means that anybody else who came in and wanted a secured loan would have to take a back seat to them. However, Even when the bank says, I'm taking a lien on everything, if you purchase a piece of equipment, you can grant a lien in that specific piece of equipment to the person who sold you the equipment that's separate and apart from the general overall lien. So both creditors would be on equal ground, but only with respect to the collateral that protected them.
Litigation. Is this ever tried? Is there a jury that gets involved here? Does the judge make ultimate decisions? Where does this really end up going when it doesn't go well?
Well, in bankruptcy court, you're generally not entitled to a jury trial. That's a complicated discussion left for another time. But for the most part, these issues are decided by the judge. Now, there are exceptions to that. If you have existing litigation that's going on when the bankruptcy is filed, the bankruptcy judge may say, I'm going to stand aside and let the state court make this decision. There are a lot of varying reasons why that would happen, which is beyond the scope of what we're talking about today. So it could be the bankruptcy court, it could be the state court. It's more often the bankruptcy court.
Most importantly, where do we find you? Because I'm sure there's going to be businesses out there that unfortunately are going to need your help. Where do we grab you?
Okay, name of my firm is Rich Michelson Magaluf, and we're located at, in Manhattan, and our telephone number is 646-453-7853.
Okay, if you had to give one tip to somebody who's watching today and things aren't going well, what would you tell them?
I would say talk to the lawyer and don't wait until it's too late. Ostriches often get punished.
I like it. All right, Robert, good seeing you again, and hopefully you'll come back again.
Thank you, I will.
All right, we have to take a quick break, but don't worry, we'll be back with more of Today's Verdict right after this.
For all the papas out there, let's stop what we're doing and take a moment. A moment to be with our kids. They can be loud moments, goofy moments, sporty moments, dorky moments, kooky moments. Moments where we talk or walk or just hang out. It doesn't really matter. They all count because every time dads take a moment to be with their kids, well, it's pretty momentous. So let's all take a moment to make a moment today.
How can I help my daughter with her reading?
Searching for help with dachshund breeding.
No.
Let me try. Sarah's bright, but when she's reading, she has trouble sounding out words.
Playing world music.
What?
I give up.
Wait, I was trying to show you how Sarah feels every day. Frustrating, isn't it? Redirecting to understood.org.
Join parents and experts at understood.org, a free online resource about learning and attention issues to help your child thrive.
Welcome back to Today's Verdict. I'm your host, David Lesch. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Discrimination is rampant throughout the workplace. It can affect your mental health and your paycheck. Here to tell us more about your rights as employees, attorney Dana Lassi. I got the last name right. I'm so happy. Dana, how are you doing?
Good, how are you?
All right. There are many forms of discrimination in the workplace. Let's get to that first. Tell me about the various types of things that unfortunately people have to deal with unexpectedly.
Our state and city law protect against a wide array of types of discrimination. What I generally see in my practice is allegations of race discrimination, sex discrimination, age, disability, religion, but a lot is protected. And if you feel like you're being treated differently, for a reason that's not fair, you should talk to a lawyer because, for example, our laws protect against discrimination based on your genetic profile.
Really?
Or your familial status. You know, you're a parent and maybe your employer's a little concerned about that.
So, you know, let's take it back to the time where somebody's actually applying for the job. They're sitting in an interview with a prospective employer. There are some no questions, right? Tell me some of the things that, before you even have the job, there's already a sense of discrimination.
Yeah.
Give us a few.
Employers should not be asking in the context of an application process about a disability. That's a definite no-no. Once they've made you a job offer, they can engage in that conversation to see if there's some way that you need to be accommodated in order to do your job. But that type of question is absolutely inappropriate.
So let's say you're walking with a cane. They're not allowed to say, so what happened to you? Is that a genetic defect? Did you get into an accident? They can't ask that.
Really, they're not
They're not
supposed
supposed to.
They're not supposed to.
What about, you know, whether you have kids at home, you know, because that, in their own mind, they might say, oh, you know, this person may be running late in the morning, children have to get on the school bus, leave early for school. Can they ask those questions?
These are the types of questions that it's not illegal to ask the question, but it could be an indication to an applicant that you want to be especially vigilant. And I agree with what you said. Race and sex discrimination are absolutely rampant, and you want to look out for it.
Okay. Questions about your homeland, where you're from, were you born here? Legitimate, not legitimate?
Although asking the question is not necessarily illegal, it is absolutely unlawful for the employer to make decisions based upon that. And so, you know, one thing you can say back if a question like that is asked is, why do you need to know? And, you know, try to find out what the employer is thinking
Sure.
in asking those questions.
Right. Luckily, or hopefully you get the job. Things go pretty smooth. You start working there. How does it work? Are you given a pamphlet telling you what your rights are? Do you go to HR? How do you find out what is appropriate and not appropriate based on the particular company you're working for?
Under New York state law, the one type of training that's absolutely mandatory is sexual harassment training. That needs to happen annually, and that's a law that came into effect recently, so everyone watching today should have already had their mandatory sexual harassment training for this year. But otherwise, what I think employees need to do, and it's not just employees, it's contractors and people who work inside a company, even if they're not categorized as an employee, is to be aware of how they're being treated. And New York state law is pretty favorable. If you receive inferior treatment compared to anyone else with whom you work, and you think it's based upon race, sex, disability, religion, age, any one of these protected categories, you may have a claim.
Let's talk about discrimination based on skin color.
Yeah.
And we're not necessarily just talking, you know, black, white. We're talking shades, am I correct?
Yes.
Tell us a little bit about that.
So that's illegal under federal, state, and local law, and it's discrimination based on color.
And how would an employer even discriminate based on shades? How does that work? Would an employer say, you know, lighter skinned people work in some portion of the company, darker the other? How would you even know if that's going to be an issue?
I try to tell my clients to actually trust their intuition. They generally will know if they're being treated differently for a reason that doesn't seem fair. But what they would need to prove to win in court is that there's someone else with whom they work who doesn't share the characteristic, you know, the darker skin color, and they're being treated more favorably. That's what you would need to prove.
Okay. Speaking of the favorably, what are the types of things that somebody is getting the benefit of that you are not because of a form of discrimination?
So of course it could start with hiring. You don't get the job. But once you're on the job, pay, promotion, more favorable hours of work, opportunities to work overtime. You know, employers sometimes think that they're being helpful and they'll say to a working mom, well, I know you have a lot to do at home. I'm gonna let the guys do the overtime. Well, that's not their decision. It should be provided equally to everyone.
All right, I'm gonna put on the employer's hat for a second, all right? And I say, well, Dana, you know, I have 15 employees, they all want overtime. Everyone's vying for, you know, the position to move up. You know, I'm just doing the best I can here. What do you say when you say, well, the best you can isn't good enough based on what other people are telling me? I'm sure you hear that excuse all the time.
Mm-hmm. What an employer would have to prove in court is that they have a legitimate, non-discriminatory reason for whatever decision they make, whether it's availability of overtime pay, whether it's a decision to terminate someone or involuntarily transfer them or demote them. So any sort of stage in your career where the employer is making a decision, if you feel it's discriminatory, they would have to offer up a reason that they did it that was not based on discrimination.
All right, so many different forms of discrimination. We have based on sex, gender, disability, go down the whole gamut. Your practice, where do you seem to see the most in what particular category?
Definitely race and sex discrimination come up often, unfortunately, and sexual harassment is a major problem throughout many workplaces. Gender identity and gender expression is recently protected by New York state law and by New York City law, and that's an area that's sort of emerging and is really important.
Question for you. Somebody comes in for a job interview and you legitimately do not know whether this is a male or a female sitting in front of you. You don't know, you can't tell, you're not sure, but in your mind you wanted this position for a woman or this position for a man, but you can't ask, can you?
Well, you can't decide that a position is for a woman or for a man unless it's
But here's the
an
thing,
acting
in their
role.
mind they're thinking this, and whether you can prove it or not, you probably can't, and you shouldn't be doing that. But let's say that particular person wants to know whether they're interviewing a male or a female. They can't ask, can they?
I think what employers need to get comfortable saying is, how should I refer to you? What pronoun do you prefer?
Right. Okay.
And employees who might be using a pronoun that wouldn't be obvious need to be able to tell
What about
people.
bathrooms? Do you have to give gender-neutral bathrooms? How does that work? I mean, it gets very complicated.
Employees should be able to use the bathroom of their choosing. And you know, it's a culture change that we're going through, and employers need to sort of get on board.
Okay, so now somebody comes to you, they say, Dana, I'm telling you, this has been rampant throughout the business. My friend tells me the same thing. She also has had problems. Help me. What do you do?
We would have a consultation and talk about what's happening and what's the evidence. You know, in what way are you being treated differently from someone else, and how can we prove it? The great thing about the laws that protect us against discrimination is that they provide for attorney's fees. So there are incentives for lawyers to take these cases, to pursue rights, and if you've been economically harmed, you can be entitled to damages.
What type of evidence are you looking for, and what type of evidence can the employee legally acquire? I'm sure there is things that they may not be able to do. I'm not quite sure what they are, maybe wiretapping, I don't really know, but tell me some of the legitimate things they can do to build their case for you.
There's very rarely a smoking gun. You know, employers very rarely say, I really prefer that the guys do this job. But there are sometimes documents that employees come across that they realize would help their discrimination claim. Take a copy. Emails to your personal account and hang on to it. If there's a work rule that prohibits you from doing that, you want to be careful. But it's generally not illegal to hang on to emails or other documents at work. And recording.
I was going to say, video. You got a little cell phone, no one knows, you're videotaping your conversation. Yes, no?
It's not illegal. What you want to find out is whether there's a rule in your workplace that prohibits you from doing it. And you know, many employers don't have those kinds of rules in place.
Okay. There's something called the EEOC, am I correct?
Yes.
What does that mean, and where do you have to go to make all this happen, by the way?
If you believe you've been discriminated against, you have to file a charge with an agency. It could be the EEOC, which is the Federal Equal Employment Opportunity Commission, or you could file with the New York City Commission on Human Rights or the New York State Division on Human Rights.
They all work together?
Well, they do similar things
Okay.
in their own jurisdiction.
Do they communicate with each other?
They do.
They do.
So if you filed a charge with the city, it'll be considered cross-filed with the federal government. And once you get a decision from one of those agencies, you'll have the opportunity to pursue your case in court.
Tips. Someone's watching right now. He or she is having a difficult time at work, and something doesn't feel right. They're very uncomfortable. What would you tell them to do?
I would say keep a record of what has happened to you. It's extremely difficult for any of us when we go and talk to a lawyer a few months later to recall in detail what has happened. Write it down. Gather the evidence that comes across your desk. Make a complaint, because if you have complained about discrimination, and then you're treated worse afterwards, you now have a retaliation claim.
Most importantly, where do we find you?
I'm at Levy-Ratner. We're on 14th Street and 8th Avenue in Manhattan, 212-627-8100.
Perfect. Dana, you'll come back, all right?
Great to see you.
Wonderful. All right, well, that's all the time we have for today. I'd like to thank our guests for joining us, and of course, you, the viewers, for watching. If you missed any part of today's show, be sure to check it out at bronxnet.tv. Also, remember, if there's a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesch@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag Ask Today's Verdict. For myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach a verdict. We'll see you in 2 weeks.